Hi everyone, welcome to episode 29 of the podcast. For today, we're going to do a review of the right of states to regulate and also the domestic regulations provisions under the Protocol on Trade in Services. State parties have a right to regulate or introduce new regulations in respect of services and services supplier in order to meet national policy objectives, as long as such regulations do not impair the rights and obligations under this protocol. For domestic regulations, the protocol provides as follows. In sectors where specific commitments are undertaken by state parties, each state party shall ensure that measures of general application affecting trade in services are administered in a reasonable, objective, and transparent and impartial manner. So what do you mean by measures of general application? They are basically laws, regulations, decisions, or administrative actions. So whatever measures, they must ensure that it's applied in a reasonable, objective, transparent, and impartial manner. I mentioned, in previous episode that there are currently 5 priority sectors that are being negotiated. I'll just do a reminder, that's transportation, the financial sector, the communications sector, tourism, and business services. So where specific commitments have been undertaken in respect of these sectors, each state party shall ensure in its own territory that whatever measures, whatever laws, whatever decisions, whatever administrative actions are going to affect trade in services, then it must be those actions must be administered in a reasonable, objective, and transparent and impartial manner. That's the first. The next provision: state parties are to maintain or institute judicial, arbitral, or administrative tribunals or procedure in situations where an affected supplier request for a review of an administrative decision in respect of trade in services or for remedies for an administrative decision. So the tribunals, they are to conduct that review within a reasonable period of time. And in case in a situation where the agency, that's the regulatory authority, is the one that is handling the procedures for the review or in charge of the procedure for the review, the state parties are to ensure that the procedure for review is objective and impartial. Finally, where an authorization is required to supply a service that has been liberalized under the protocol, the relevant or the competent authorities of a state party shall, within a reasonable period after the submission of an application that is complete, a completed application as required under the domestic laws or regulations, they shall provide a decision to the applicants within a reasonable period after the submission of the application. And also where a request is also made for the status of an application, they are also to provide a status report within a reasonable time frame as well. So if, for instance, a Kenyan national wants to supply a service in Ghana and Ghanaian laws or regulations require that an application has to be made to the relevant Ghanaian authorities in order to provide that service, the Kenyan national must submit the complete application as required by the law. And once he has done that, the Ghanaian authorities, the relevant regulatory authorities, are to provide a decision within a reasonable time after submission. And where the Kenyan national requires a feedback or a status report in respect of his application, they are also to provide that without delay. We have come to the end of today's podcast, and as usual, the podcast is basically just for educational purposes to educate the public. If you need an expert's advice in respect of trade, please reach out to me, or you can reach out to a trade expert around you. Until next week, Thursday, I say bye-bye.